Hi, I'm Tia, and welcome to another segment of My Kids Point of View.
I'm here at the Washington County Courthouse to meet with Prosecutor John Threet, Crime Scene Investigator John Brooks, and Judge William Story. I wanted to get their views and ideas on DNA testing. I feel that there should be a national database for DNA, and that we could do that without infringing on the Fourth Amendment. I feel that if people want to collect welfare benefits, have a driver's license, engage in an occupation that requires fingerprinting, all legal and illegal aliens, as well as anyone, an adult or juvenile, arrested for misdemeanor or felony, should be required to provide DNA. Having the database will help investigators, prosecutors, and judges. It will lower the cost of a criminal investigation, probably lower the crime rate, help locate missing children, and more.
I'd like to introduce Prosecuting Attorney John Threet and Crime Scene Investigator John Brooks. Thank you for meeting with me today. There's been an ongoing debate about mandatory DNA and national database. As you probably know, Denmark has been collecting DNA from every child born since 1981. DNA databases help some crimes help protect citizens and their property rights, including the right of victims to justice. Many feel that this more than makes up for any minor privacy rights violated by mandatory DNA databasing, making it a net gain for individual rights. Is there a national database for DNA now, and if so, whose DNA is included in the database?
Yes, there is a national database.
Okay.
And it depends on what the states require of the usually it's going to be just people who are convicted of crimes in general. And each state probably varies in what who they require to give DNA samples. Also, unknown DNA samples can be entered, like when John collects DNA and we don't have a suspect, don't have a known suspect, they can submit them into that national database and then sometimes try and get a hit.
Okay. If there was a DNA database which consisted of DNA from everyone with a driver's license, everyone receiving state or federal welfare benefits, all legal and illegal aliens, anyone arrested for any offense, felony or misdemeanor, juvenile or adult, and all people who are presently required to have fingerprints on file, what effect that would have on the criminal justice system?
It would probably, it would be a good thing as far as, so many times we go out, we collect a sample, we don't know whose the sample is, it gets entered in the database, and if they're not in there, it's not ever going to hit. And so if it was in there, obviously it would hit, but then you have rights issues, you have things like that, but yes, it would help, in my opinion, yes.
Okay.
And we had a case in Fayetteville on a rape case, unknown suspect, and actually had a real good suspect, and he was actually at one point arrested. His DNA, it cleared him. DNA testing cleared him, and then in the national database, they entered, Fayetteville police entered the unknown suspect's DNA in the database, and the suspect was caught in Florida. That matched his DNA, and then through the investigation by Fayetteville police, they were able to determine that he had been working in Siloam Springs, that he had been coming to the Fayetteville area. So DNA in that one example both eliminated someone and then found the actual criminal who had committed the crime.
Okay. If the police suspected a person of a crime and matched the DNA from the database, wouldn't that make it faster to make an arrest to save thousands of dollars required for investigations?
It's very possible. There's a law, a new law on the books. It's been on the books for a couple of years called Julie's Law, and it basically gives the investigative, or actually the booking agency, the right when they're booked in on certain charges to go ahead and take their DNA upon arrest, not upon conviction. And the purpose of that is so that if you have a serial rapist, murderer, or a person that's just a serial criminal that's out there, that could potentially stop because you're going to enter it in the system upon arrest and not upon conviction. Because now, for most offenses, it's upon conviction, not upon arrest.
Okay.
I don't know if you got anything to add to that, or
Okay. Would that lesson work for the judges and prosecutors who would have otherwise had to issue search warrants?
Yes. if you're not having to, if you're not being required to issue a search warrant, then yes. Although, search warrants are not always that time consuming. It depends on what you're looking for and how you're writing it up. But certainly that would eliminate as big a need to do that. The problem is, it's not really a problem, but when you get a hit, such as the one that I was talking about, the guy in Florida, you're still going to have to recollect the DNA because you've got to prove the chain of custody. And you won't generally be able to prove a chain of custody from someone who had a sample entered 2 or 3 years ago in Montana. We're not going to be able to prove that in court. So once we get them back, Brooks is still going to go over there, collect a DNA sample, resubmit it. It's going to have to be retested just so we can prove the chain of custody in court before it's admitted into evidence. So we still have to redo that. And when we redo that, we're still going to have to get a search warrant because it is a search.
Okay.
So like for instance, if you go out to a scene, say you go out to a burglary scene and the person's cut themselves and you collect their blood, you send it down, and it may be 6 months before you get that analyzed, but you do get a hit, and they give you what's called a investigative lead letter. And basically what this letter says is, based on the evidence that you submitted, it is consistent with or matches this person. But in this letter, it says 3 or 4 times this is an investigative lead. And so what that does is then at that point you go out and get the confirmatory samples from the person, send it back down, and the crime lab will confirm that in fact is the same person that it hit on. Does that make sense?
Yeah, that makes sense. Do you think that if there was a DNA database that people might think twice before committing a crime and that the crime rate would eventually go down?
That's one of those philosophical things. You're the philosopher between the two of us.
I think, this is my personal, I think that there's going to come a time, and there's going to come a time for law enforcement that because DNA technology has gotten so sensitive and you can pick up DNA off a lot of things that 5 years ago you couldn't, that all police that are in investigative roles are going to have to give their DNA. All the people at the crime lab now have to give their DNA so that if somebody's working in the DNA section, they may be a person that sheds their DNA and they may have a profile, and they need to know what
to eliminate
them. And so just like with us going out on the scene, there may be some contamination that was an accidental contamination, and they're going to have our sample to be able to. So I think the way things are going, it's coming that there's going to be a lot more people put in there that are in there.
Okay.
Right.
And you touched on it, but explain touch DNA, which we didn't have more than 3 or 4 years ago.
The idea is that if you have a fingerprint that's not a complete fingerprint, in other words, it doesn't have ridge detail on it, but it's a smear, that you can actually lift that like you would a fingerprint, and then you can actually take that and swab that area and be able to get the skin cells that were deposited there even though a fingerprint wasn't left. Or if you have an item that is a rough surface, say something that's rough that wouldn't contain a fingerprint, but you know they handled it, you're constantly shedding your skin cells. And so what Touch DNA does is it basically, you take a swab and you're able to identify, because of the cells that you're shedding, the DNA off the person.
Oh, wow.
But not every time.
Not every time.
Just like I can touch this and move my hand, he could come in and try to get fingerprints off of it and not be able to.
Okay.
Get a good fingerprint. Doesn't mean I didn't touch it.
Yeah.
But you can't. Not everybody lays out a perfect fingerprint just because they touched it. Same thing with DNA. We've had sexual assault cases where there was no DNA left behind. Doesn't mean that the crime didn't happen. But that's just the way it is. You don't always leave. It's not 100% that you leave DNA or fingerprint evidence behind. It doesn't mean it didn't happen. You just don't always have it.
Okay. Do you think that in the cases of infant and child abduction, such as Carlina White from New York, Christy and Bobby Baskin from Tennessee, and Sean Hornbeck from Missouri, do you think that regular searches of a DNA database could have resulted in these victims and others being found and reunited with their family much sooner?
That'd be you. You read. and keep up on these national things.
You mean that if their DNA was in there, then potentially you could? How I'm confused on the question. I guess a little
Well, I guess.
Well, that would only work if there is DNA left behind.
Right.
Okay.
So
Right.
and they would have to know where that DNA was left behind.
Okay.
So in other words, if somebody has abducted someone and they've been someplace, number one, the police are going to have to know that they were there, and then number two, that suspect is going to have have left some DNA behind for them to find it. Now, if those things take place, if the police know that the suspect has been there and can find some DNA, then if that suspect's DNA is on some database, then yes, that would help.
Okay. Does the Fourth Amendment apply to choices that people make? Like, it's a choice to have a driver's license, it's a choice to immigrate to the United States, it's a choice to violate the law, a choice to have profession or business that today requires fingerprinting, and a choice to receive welfare benefits. Some people say the main argument against the National DNA Database is that it violates the right to privacy, but that this argument does not hold up well to scrutiny. The mere act of collecting DNA information does not in any way violate the rights of individuals to act in any way they choose, in their own private lives. Your thoughts on this?
That'd be your question, since it's Fourth Amendment question.
It's really two separate issues. The Fourth Amendment applies if it's a government intrusion, which what you're talking about probably would be basically a government intrusion.
Okay.
And the Fourth Amendment would apply. When people go and choose to commit crimes, the Fourth Amendment still applies. We don't suspend the Constitution. And the Fourth Amendment basically says that people should have a right to be secure in their selves, their person, their houses. I believe that's the term they use. Their personal effects. They have a right to be secure in that, and separate apart from the government coming in and going into their homes or searching them. And the Fourth Amendment applies to murder suspects. Murder suspects who are caught on videotape and have confessed to the crime. Our Constitution, the Fourth Amendment, still applies to that person. So you can think of the worst scenario that someone may have, some crime that somebody may have committed. Fourth Amendment still applies, which means they have to get a search warrant or some exception to the search warrant. And I don't see that ever going away in the United States of America, because we are so closely, tied our identity to the Constitution, to the Fourth Amendment, to the amendments that we have. That's basically our identity. That's the way we conduct ourselves, is we follow those laws. So I don't see the Fourth Amendment ever going away. Now, there are different court decisions on the Fourth Amendment where the judges will determine, appeals courts will determine, we believe the Fourth Amendment means this in this case. Those things will vary and change, but the Fourth Amendment, in my opinion, will always apply.
Okay.
In your comment about Denmark, everybody giving their DNA since 1981, what's the crime rate in Denmark? I mean, do you know? My understanding is it's very, very, very low. I mean, very, very low. Much lower than here. And I don't know what that.
Have you spent a lot of time in Denmark?
No, but I know that crimes typically over in Europe and places like that, excuse me, are lower than they are here. And so I don't know if that plays a part in it, that people over there voluntarily give their DNA, and there's no question about it because they don't have a lot of crime.
I mean, yeah. I know that another concern is the cost of collecting, testing, and storing the samples. What costs do you think would be involved if the testing became mandatory?
Yeah, you could answer that on the backlog too. How far behind we are now on collection, storing, entering.
When I first came to work in 2001, there was a backlog of about 250,000 cases. In other words, there was 250,000. I'm just giving a close number that were sitting on the shelves that they hadn't been able to enter into CODIS, which is the database. And over time through grants and sending it out and things like that, they got all those caught up. There's probably still somewhat of a small backlog, but nothing like there was. But because technology's increased, the testing's gotten cheaper. I can remember a time when testing on a murder case, the crime lab would only test a couple of items because it was so expensive. And now the testing prices have gone down, and so you're able to get a lot more things tested. And I mean,
And we also have our own state crime lab.
Right.
I'm so old that when I started out, we didn't have DNA testing at our state crime lab. If we could get DNA tests, get it collected properly at the scene, and get it sent off, it went to Quantico, Virginia, and so that's where our DNA testing came from. If we were even able to collect it, but based on because DNA testing, I think the first successful case was '83. Isn't that right? In England.
a little bit later than that, I think, but it was in the 80s for sure.
And so it was still relatively new when I was starting out, and based on training, everything goes, things like that go back to training your police officers in collection, having someone like John Brooks who knows how to collect that evidence, to keep that evidence, and to ship and how to ship that evidence, and then having the resources to get people to test it.
Let me give you an example. In 2003, the first murder case I ever worked, it occurred in January, or that's when we investigated it. It was April before we got our first DNA sample or analysis. In that particular case, they did, if my recollections were right, they did 3 samples. There was actually 2 more samples that were discovered later through the investigation that needed to be tested. They would only test 1 of those because the cost was so high. It took 4 months. They would limit you to how much you could test, not because they didn't want to do it. It was just it was a cost issue. Well, the now on not even a murder case, you can get 5 or 6 samples done, and you're getting it back in as little as 3 or 4 weeks. So that's where we've come from 2001 or 2003 till now. It's gotten a lot faster. You can get multiple samples tested because the cost has gone down.
Yeah. Do you think that some of these costs could be passed down to individuals and their licensing fees, renewal fees, and court costs, as well as the overall savings in investigations, prosecution, and overall reduction in crime?
You're talking about the people collecting?
Yes.
The people that are collecting are, and that goes back to why you have to go back and get a confirmatory swab, because you have people that are working in jails that are booking these people in, and they're taking a sample, and when and if their sample ever does hit, they may be long gone from law enforcement, and so that chain of custody that John was talking about is gone. So you're going to have some way of having people that are qualified, certified to take those samples, and not just have random people taking those samples, because I think your chain of custody is really going to be called into question.
Okay.
But as far as how to pay for it and the revenue, I mean that'd be a political question for someone of how they would actually pay for it, and generate that revenue. The problem a lot of times that people say is, well, we'll make the suspects pay for it. And that's fine, and in theory that sounds great, but a lot of, you've got somebody that didn't have any money to begin with, and he gets caught for stealing something. You can order him to pay $1,000 if you want, but if he doesn't have it and he's not going to get it, then you're not going to have that revenue coming in. So you have to make sure that you have a constant stream of revenue on anything you're trying to fund that needs to stay. If there's some way that you're wanting to set up a different system for the DNA collection and storage and all that, you have to find some constant stream of revenue, which is where it comes into the political question of how the legislators want to fund it.
Okay.
I'm sure Judge Story will talk about this, but when a person's convicted, the DNA fee is $250. Right? I mean, and you'll hear, anytime there's a plea or whatever, the prosecutor's going to say he's required to pay the $250 DNA fee, and I don't know how often or how, that gets actually paid by the defendant. I'm assuming it does, but
It does. I don't know what the percentage.
Okay. Some think that the only people worried about having their DNA in the database are those who think that they might commit a crime in the future. It's sad that until they are a victim themselves, they can't appreciate what a DNA database could do for them. So, thank you so much for meeting with me today.
Thank you.
You're welcome. Thank you.
I should have been more specific with my question about infant and child abductions, such as Carlina White from New York, Christy and Bobby Baskin from Tennessee, and Sean Hornbeck from Missouri. Carlina White, Christy and Bobby Baskin probably had a driver's license, had their DNA already been in the database from the time of their abduction, and if over the years regular searches of a DNA database were made for a match, it seems to me that when they applied for the driver's license and gave their DNA, that they could have been found. That is, of course, if there was a mandatory DNA requirement. After my meeting with John Threet and John Brooks, I did some research about Denmark's crime rate. You may recall this was a question brought up in our meeting. I found an article titled, "A Comparative Criminology Tour of the World," written by Dr. Robert Winslow from the San Diego State University. The article compared data collected from Interpol for the year 2000. According to Interpol data for the year 2000, for murder, the rate was 4.03 for Denmark and 5.51 for the U.S. For rape, the rate was 9.32 for Denmark and 32.5 for U.S. For robbery, the rate was 59.14 for Denmark and 144.92 for U.S. For aggravated assault, the rate was 23.68 for Denmark and 323.62 for U.S. For larceny, the rate was 1224.71 for Denmark and 2475.27 for U.S. But I found the results interesting for burglary and motor vehicle theft. For burglary, the rate was 1868.06 for Denmark and 728.42 for U.S. And the rate for motor vehicle theft was 604.18 for Denmark and 414.17 for U.S. To find out more about the cost for DNA testing, I communicated with Kermit Channel, director of the Arkansas State Crime Laboratory. He said it takes approximately 24 total hours to complete a sample, costing about $50 per sample. From convicted and or arrested individuals are run in batches, approximately 80 samples per batch or plate. With the current technology, 300 to 400 samples can be run and analyzed per week. He said that if there were laws requiring DNA collected from anyone requiring an Arkansas state driver's license, we would need a new lab and staff. Arkansas has approximately 2.9 million people that would require testing. It would cost about $2 million staff and equipment alone. Personnel wouldn't be hard to find, but we would need to train them, which is an ongoing expense. Judge Story, thank you so much for meeting with me. I wanted to get your input on a national DNA database requiring mandatory DNA testing for individuals who make certain choices. If there was a DNA database which consisted of DNA from everyone with a driver's license, everyone receiving state or federal welfare benefits, all legal and illegal aliens, anyone arrested for any offense, felony or misdemeanor, juvenile or adult, and all people who are presently required to have fingerprints on file, what effect that would have on the criminal justice system?
It probably would have some effect on the criminal justice system, but I think it would be exceedingly difficult to pass legislation that would require certain segments of our population to provide DNA samples without, in effect, committing a crime as the law is now. For example, people who are charged with crimes and there's reasonable or probable cause to suspect that they have committed that crime, it's still necessary to obtain a search warrant to, in effect, obtain material from them to do a DNA analysis. So presently I'm not convinced that such legislation could ever pass. And if there were an attempt to do that, I think that you would have to include everybody, every adult in our population. I don't think you could just single out, for example, illegal aliens or people with driver's license or one particular group and to the exclusion of others.
Okay. If the police suspected a person of a crime and matched the DNA from the database, wouldn't that make it much faster to make an arrest and save thousands of dollars required for investigation?
Maybe in certain situations it would result in an arrest made easier by having that information on file. But generally speaking, in most crimes that I see, DNA is never really a part of the process. In other words, in certain types of crimes, for example, sex crimes, we obviously DNA is very helpful in solving the particular crime and bringing the perpetrator to justice.
Okay. Would that lesson work for the judges and prosecutors who would have otherwise had to issue search warrants?
Well, of course, search warrants are a fundamental part of our judicial process, and search warrants are necessary because we have constitutional rights requiring reasonable or probable cause before an intrusion on a person's rights is made. So, in effect, it might be easier and less work, but on the other hand, there may be serious constitutional questions in those situations.
Okay. Do you think that if there was a DNA database, that people might think twice about committing a crime, and that the crime rate would eventually go down?
Probably not. We have enacted legislation for certain drug crimes, for example, that would require or result in life sentences for people manufacturing methamphetamine, and yet people continue to manufacture methamphetamine. And we have serious and severe sentences for other types of crimes, and yet people continue to commit those types of crimes. So I doubt that it would have much of an impact on the crime rate.
Okay. Does the Fourth Amendment apply to choices that people make? It's a choice to have a driver's license, a choice to immigrate to the United States, a choice to violate the law, a choice to have a profession or business that today requires fingerprinting, and a choice to receive welfare benefits. Your thoughts on this?
Well, my thought is our society in general, and I'm referring, of course, to society in the United States as we know it, is founded on the principle of due process of law. And if we continue to erode the Fourth Amendment and perhaps other safeguards that citizens enjoy and appreciate and understand, then I think we have a serious situation. Please understand, I'm all for fighting crime, but I still think that it's terribly important that we adhere to the principles set forth in our Constitution, the United States Constitution and the Arkansas Constitution.
Okay. Thank you so much for meeting with me.
Well, Tia, thank you. It's been a pleasure. I'm very impressed with what you're doing here.
Thank you.
And I hope I've sort of answered your questions.
After my meeting with Judge Story, I was given the opportunity to visit the Washington County Detention Center. There, I met with Chief Deputy J. Cantrell. He then arranged for me to meet with Demetrius Jones, an inmate and trustee. Demetrius Jones was convicted of being in possession of cocaine. What were you first convicted of?
Possession of cocaine.
And if the DNA was in the database, would you have changed your decision about that?
No, ma'am.
If it was mandatory to have that when you got your driver's license?
It wouldn't be a problem.
I wasn't surprised that Demetrius said his actions wouldn't have changed if he knew his DNA was already in the mandatory database. His crime was not a violent crime. I can't help but wonder if I had interviewed a pedophile or a rapist, if the answer would have been different. I also asked Demetrius what effect he thought mandatory DNA testing would have on the judicial system.
Yeah, a heavy workload.
Okay. Well, I guess that's all we have to ask you, so thank you so much. While I was at the Washington County Detention Center, I was able to see a holding cell firsthand. It is certainly a place I never want to be. My kid's point of view is that there should be mandatory DNA testing. If that is impossible because of the Fourth Amendment, then I do think it should really be considered the same as fingerprinting, which is also covered under the Fourth Amendment. Mandatory fingerprinting is required for certain occupations, required for people that have an alien registration card, and for people that are arrested. DNA should be no different. It's in everyone's best interest to lower the crime rate and reunite abducted children with their families. Maybe one day Morgan Nick will be reunited with her family. She was abducted June 9th, 1995 from Alma, Arkansas. She was only 6 years old. In August 2011, the FBI came up with the FBI Child ID app. It's available free from the iTunes Store. The FBI is working to publicize the app with the American Football Coaches Association, its longtime partner in the National Child Identification Program, which provides a physical kit to gather your child's pictures, fingerprints, personal characteristics, and even DNA to keep with you in case of emergency. I want to thank Washington County Prosecuting Attorney John Threet, Crime Scene Investigator John Brooks, Circuit Court Judge Judge William Story, Chief Deputy Jay Cantrell, Trustee Demetrius Jones, and the Director of the Arkansas State Crime Laboratory, Kermit Channel, for all their contributions to this program. If you have any comments about this show or anything you'd like to see me cover, please email me at mykidspointofview@gmail.com. But remember, my parents do review all my emails before I do, so anything inappropriate will be deleted. Thanks for watching, and see you next time.